Welcome to the Business Law, Estate Planning, and Estates Podcast.
Hello, and welcome back to the Business Law, Estate Planning, and Probate Podcast with attorney Thomas LaPorte. Thomas is the founder of LaPorte Law Group, PLLC, with offices in Portsmouth, New Hampshire, and North Andover, Massachusetts. With more than 25 years of experience, he helps individuals, families, and business owners protect their assets, plan for the future, and navigate estates and business matters with clarity. I'm Lisa Mosbey, and today we're talking about buy-sell agreements and cross-purchase agreements. Thomas will share how these tools help business owners plan for ownership transitions, when a partner leaves the business, retires, becomes disabled, passes away, or when ownership needs to be transferred under an existing agreement. Thomas, thank you so much for joining me today.
Well, thank you. Good to be with you, Lisa.
Well, why don't we start with the definition? Let's start with what is a buy-sell agreement?
A buy-sell agreement is a document or part of a document, and I'll explain that in a minute or two, that provides how a business owner, when they're ready to leave, retire, if they pass away, or they can no longer operate the business, how that person's ownership interest, whether they be shares inside of a small corporation or large corporation, or membership interests within an LLC, how those are disposed of, and that owner that we are referring to that can no longer operate or doesn't want to operate the business, how is that person's shares being purchased? Now, so the shares or the membership interests are being exchanged for money. So the buy-sell agreement incorporates those terms.
And then how is that different than a cross-purchase agreement?
Well, a cross-purchase agreement is a form of a buy-sell agreement. So the buy-sell agreement is the universe. A cross-purchase agreement is within that universe. And the only difference is that the parties are fellow members within the company, within the corporation or the LLC. So the purchaser is another fellow owner. So that's why, I don't know why they call it cross-purchase, but that's the difference.
And then who buys the ownership interest?
Well, say, Lisa, you and I have a shipbuilding company, very important company, and I want to buy your interest out. You've hit the lottery, and you no longer need to build ships, so you're going to depart. And by the way, there were 4 Ds, which are scenarios where that usually trigger a buyout or a cross purchase. They are, you want to depart, like we just talked about, you won the lottery, one gets divorced, person dies, like we all are going to, or one becomes disabled for a period of time, say 6 months, where they can no longer perform essential functions. And this is important in a small company. So what happens is we have a cross purchase agreement, we have a standalone document that an attorney has prepared, or it's within our operating agreement, which is the same thing as bylaws for a corporation. You're departing, and the agreement says, this is what I'm going to buy. This is the amount that I'm going to buy your shares for. These are the terms. I'm going to buy it over time, or I'm going to buy them all up front. We agree in advance on what the price will be, or since we may not know what the fair market value will be when before the event happens, we agree on a system as to how to appraise your shares using a business evaluator, for instance. Or if we disagree on that, we'll choose an average. There's different ways to solve that problem. And then we simply agree, you and I, because we want cash flow to stay within the company, not for it to operate, but you want your money too. So perhaps what I do with my clients is, depending on what their needs and abilities are, we'll give you a certain lump sum, say 40%, then the rest will be paid out over 3 or 4 years. And you get security to make sure I continue to pay. So you secure the purchase agreement with your shares you're giving to me. And if I don't perform, you get the shares back. So that's a scenario of doing it. I know we may get to it, but a way to fund that agreement, I may not have a lot of money personally to buy your shares, so we can buy insurance on each other's life. It will cover only dying and disability because the policies available are life insurance and disability insurance. That's a source of funding to fund an agreement, a buyout transaction.
And what's the role of the life insurance, or how is it used?
Well, there's two ways to incorporate insurance and leverage those premium dollars. People often say 10% of premium dollars will result in 100% cash. It's a good tool. So in a cross purchase agreement, there are two versions. Each of us in our shipbuilding company, Lisa, you'd buy a policy, a life insurance policy, perhaps a disability policy as well, on me. I do the same thing on you. So I'm the owner, you're an owner, and on your policy, I'm the insured person. On my policy, you're the insured person. So we can only cover the two of the 4Ds, like I said, death or disability. But when I pass away, I have the bad sense to pass away on you. The insurance company now is bound because the events happened, and you just contact the insurance company. They verify that I'm passed away, and they give you the $1 million or the $2 million or whatever amount has been purchased, and you will use that money to buy out my spouse because she's most likely, or your partner's most likely going to inherit those shares or that interest, or my estate, could be my kids. So my spouse doesn't know how to build ships, has no interest in building ships. Same with yours. So instead of inheriting my interest, they inherit the insurance dollars, and now you own the entirety of the company. You know what you're doing. You will continue operating it.
So that buyout is basically pre-negotiated for the price of the insurance? Is that how I'm hearing this correctly?
No, that's it. It oftentimes is. Sometimes, however, if the appraisal really still should do an appraisal. I think it's silly to try to agree on a value in advance. We just don't know what the value is going to be 20 years later, for instance, or 10, 15 years later. How can you tell? Shot in the dark. So perhaps we have $1 million coverage, and my shares are worth, or my membership interest in the LLC are worth 1.2. Well, in our agreement, we're going to fund your purchasing of buying out my estate, buying out my spouse, as much as we can with the insurance dollars, and then we'll have other provisions say if there is a delta, if there's an overage, in this case $200,000, we have terms as to how that's going to be paid out, perhaps over time. So not to hamstring the company, which you're running, take a big chunk out of the cash flow, but you pay me a reasonable interest rate. Right now, 6.5%, a reasonable term, maybe not 10, maybe not 1, but 3. We work that out. That's how that's done.
And then what's the potential downside, Thomas?
With downsides in cross-purchase agreements using insurance, if there are many, many owners, it can get complicated. If you have 3 owners, and I won't get into why, 6 policies have to be purchased. So it gets a little bit convoluted and complicated. So in that scenario, you would have the second version of a cross-purchase. You should use the second version, which is where the company itself, and with more owners, it's typically a larger company, right? So a larger company usually has more money. The company will buy the insurance policies on each owner. So where there are many owners, or where there are owners of different ages, it's better to have the company buy those insurance policies. Now, there's a difference in some outcomes when you do that. That's called a redemption, but that's a downside of you and I purchasing the policies. If we have 4 or 5 other owners, we'd want to have the company buy the policies instead.
And then are there other solutions besides just purchasing insurance that would allow this transaction to happen?
Well, I guess a company, and I've never recommended this, they could borrow, but usually it's not from institutional lenders like banks, which would usually result in people going to private lenders. Let's call them hard money lenders. Let's call them, some of them are loan sharks. You can go to other sources to get money, but the traditional ways that fund these agreements is with insurance. I haven't had the occasion, I've done many of these, but I've never had the occasion where a person didn't qualify for the insurance, like life insurance, if someone has uh, pre-existing conditions, for instance. So at that point, I think I'd turn to a credit union or a bank, but would have to apply for the money in advance, would paying interest on that, would have to consider the timing of that and the interest payments if we can't qualify for insurance. Otherwise, if you need a SNAP loan, you're going to pay private lender rates.
And then are there tax differences between these different forms of ownership transference?
Yes, there are. The main one is in the first scenario, Lisa and Tom's shipbuilding company, we each purchased the policy. Because of that, I've passed away, if you recall. When you purchase my shares, you now receive what's called a step up in cost basis. So the value of those shares is the value at my death, date of my death, or within 6 months. That's the IRS rule. Why is that a benefit? The benefit is that later on, Lisa, when you sell the company, including my shares, which you've acquired, you bought my shares for $1 million, yours were worth $1 million at that time, you were later sell the company for $4 million. Well, you've got a step on basis, and one half of the $4 million company is worth $2 million. You've got a capital gain of $1 million only. If the company buys the shares, the gap is $2 million. We pay capital gains taxes on that. Now, it's lower than regular income tax rates. It's 20%. But the bottom line is you and I buy the insurance policies. We each get a step up in basis, which saves us on capital gains taxes when we later sell the business. The company does it. The company bought it, so you and I do not get that step up in basis. It's zero. So if you sell a company for $4 million, you're going to pay capital gains on a total of $4 million, including $2 million on mine and $2 million on yours. So that's the difference.
And then, Thomas, what are the impacts on control and ownership with a cross purchase agreement compared to an entity purchase agreement?
Well, with the cross purchase agreement that you and I effectuated, your ownership interest has increased, right? You've gone from 50 to 100%. With a buy-sell agreement that is a redemption where the company buys the shares back, my shares are retired. They become what are called treasury stock within a corporation. The effect of that is the remaining shareholders' ownership interests are just adjusted proportionally. So it doesn't result in any increase in ownership relative to another owner. And that would be particularly the case where, say, there were 3 of us. So that's the main difference.
And then how are these agreements created?
They are created in a standalone document, a contract, and that usually happens after companies formed. It's matured a little bit. People are nearing retirement. They're looking for the exit plan, and they'll come to me or someone like me and say, can you create a cross-purchase or a buy-sell agreement? You may call it a redemption agreement, and we'll put in a standalone document. Or we can include those provisions inside our bylaws if we're a corporation or operating agreement. They're one and the same, basically, if we're an LLC. And we would just have to include those provisions regarding how we value the shares when the future event occurs. So we just put together the processes in advance. We most likely do it in a standalone too, but we are so much closer to the event happening. We might then be able to say, agree on a value and avoid the cost of hiring a business evaluator. So that's how they're done. They can be done inside the Bible of the company, the rules of the company document, or it can be done as a separate document.
When is each typically used?
The cross purchase, again, is used where there are, say, 3 or less members. I've seen 4 where there's 8 policies. The redemptions are used where it's a larger company. The larger company usually has more capital and can afford to pay those capital gains taxes. And there's other deductions. You seek your good tax advisor for those deductions. And the format in which these documents are created really depends on whether or not you and I have the foresight to put the terms in our operating agreement when we started the company, or if we haven't thought about that, we want to make sure the company, becomes viable. We'll take care of that later. Then it can be done as a standalone, or we can amend the bylaws of the operating agreement. So that's my answer as to when and how.
Very good. And you've shined a lot of light on this, so it's been really helpful. Thomas, if folks would like to learn more, how do they get in touch with you to pursue maybe getting some help on this?
Sure. They can contact me through my website, laportelawgroup.net, and my phone number's on there, and there are links as well to schedule a 15-minute consultation. Just talk to me, and we'll fill it out from there. Or they can just access my firm through the link at the end of this podcast that your great company has included. So those are a couple of ways.
Beautiful. And that's where we'll leave it for today. Thank you so much.
Thank you, Lisa.
That's it for today's podcast on the Business Law, Estate Planning, and Probate podcast. We appreciate you listening, and we want to invite you to subscribe, share this podcast, or leave a review if you found it helpful. And come on back next week. We'll see you then.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.